If you're taking on the role of being a director, you've signed up for a big task.
Making sure companies are paying for performance is the biggest challenge facing compensation committees today.
Emerging markets are going to create challenges for all global companies.
Corporate Board Member presents the Board Governance Series with series contributors PricewaterhouseCoopers, Meridian Compensation Partners, and Clifford Chance. On this edition of the Board Governance Series, lessons boards can learn from past FCPA cases with Wendy Wysong, partner Clifford Chance.
Welcome to this edition of the Board Governance Series. I'm TK Kerstetter with Corporate Board Member, and we're going to be talking about an interesting topic today on FCPA. And my guest for today is Wendy Wysong, who's a partner with Clifford Chance. And Wendy, you have offices in Hong Kong and Washington, D.C. And for those of you who don't know, Clifford Chance is one of the largest and most global law firms. So it seems like FCPA should be one of your specialties, knowing that you service the world.
That's right, that's right.
I want to talk a little bit about FCPA lessons that global boards can sort of learn from what happened out there. But before we get into that, FCPA, the Foreign Corrupt Practices Act, has been a very hot topic. Just talk for a second on why that's so, why it's such a big deal for boards right now.
Sure. It's really the result of two very separate developments that have been converging in recent years. And the first development is that companies have really gotten an interest in expanding globally, and particularly into emerging markets, which is great because those countries need that investment. But companies really need to recognize that there's risks involved as well. And in particular with these emerging market countries, they have very weak legal and regulatory systems. They're characterized by endemic corruption because their public officials aren't paid very well. And there's a high degree of government involvement. So you might be partnering with state-owned corporations. You might have licensing, permitting, customs, duties, all kinds of interaction with government officials, which create a great opportunity and risk of corruption. And so companies need to understand what the risks are when they're expanding globally. And the second development that's really occurred in parallel to this is the expanding and very increasingly aggressive enforcement of the FCPA by the U.S. Department of Justice and the Securities and Exchange Commission. And what we've seen is that they're not just holding the companies liable for paying these bribes, but they've also stated that they're going to hold individuals, in particular executives, board directors, accountable for corruption that occurs in those companies.
Well, in referencing that, do you have a good example where a company has sort of run afoul of this, and then what board members can sort of learn from others' mistakes?
Sure. I think one of the examples that a lot of people might be familiar with is what happened with Siemens. And Siemens, as you're aware, is a German multinational conglomerate that expanded very much globally, and then in 2001 decided to become a U.S. issuer and list on stock exchange. And in doing so, they became subject to the Foreign Corrupt Practices Act, and they had a little trouble adjusting to being subject to the FCPA because the culture was very different than companies that have grown up in the United States and been subject to the FCPA. And so what happened was in 2008, they were fined a very heavy penalty for violations of the FCPA that occurred all over the world. They paid $800 million in penalties to the U.S. government and another $800 million to the German public prosecutor, and that's in addition to investigative costs and compliance and remediation that has been estimated to have been another $1 billion. And recently, and people have been waiting for this, just a couple weeks ago, there were 7 former executives and 1 former board member of Siemens who was indicted by the U.S. government and charged by the SEC for violations of the FCPA that occurred in Argentina. Essentially, they paid about $100 million worth of bribes to obtain a $1 billion contract to get the national identity cards in Argentina, and they paid off a couple of the Argentinian presidents and cabinet ministers. And these 7 executives are being held accountable for the corruption and the bribes that occurred. And I think what that would be a lesson for is that companies and board members in particular need to understand that it isn't just going to be the board or the company that's going to be held liable, but it also could very well be the board members who are going to be held personally liable. In addition, we've had a number of boards that have been sued, shareholder derivative suits, and have been targeted as a result of follow-on civil lawsuits arising from FCPA violations.
Wendy, it must be unnerving for directors of a public company to be sitting on a board, and they might be in a situation where they've got 25 different businesses and they're operating in 25 different countries. Some of those countries have a history of taking bribes or doing things that would be considered fraudulent under FCPA, but here they are responsible, even though they can't possibly oversee all of what's going on out there. So what would you tell a board of directors? Like, what should they be doing to sort of prevent, this from happening at their particular institution?
Sure. And we tell board members, that and looking very realistically at what they can do. I mean, obviously, their duty is to prevent misconduct. They're not managing the company, though. What they're doing is overseeing the company and making sure that there's adequate procedures and programs in place. And so the challenge is for a board member to be able to accurately assess those risks and then to deal with them realistically. And so we tell board members that there's a number of different things they can do. The first one is to accurately assess the risks that the company is facing and look at where the company is doing business, who they're doing business with, and what are their industry practices, and evaluating those to see where the risks are. Second thing we tell board members is that they need to oversee the implementation, development of a written compliance program that's not just a paper program, but it's an active program that is adequately resourced. And they need to test that and make sure that it's adequate and that it's being respected. I try and emphasize to boards that this is a very active involvement, that they should take the training right alongside with their employees, and to set an example. We call it tone from the top, and making sure that they are seizing the opportunity to create and really affirm a culture of compliance. Another way that they can do this is making sure that they appoint a compliance officer that's fully empowered, has the clout to really implement and enforce the compliance program. That's one of the things that we learned from Siemens, where the compliance director was also the general counsel and head of HR and had a number of responsibilities. You need to make sure that that person, while powerful, really can do their job and has the resources to be effective. You need to make sure that there's periodic reports to the board. How is that program being implemented? Is it effective? And you can look at some very measurable results. How many people have taken the training? Have they been tested? Have third parties been vetted? And have some third party agents been rejected because they don't meet the standards of the company? Have there been complaints by employees? How are those complaints being handled? So actively overseeing how the program works. We also recommend that board members assess and continually assess whether or not that compliance program is updated. If they're expanding into a new industry, a new country, if they're acquiring a company that is in a country of high risk, they need to make sure that their compliance program understands and addresses the risks, the new risks that might arise under the local laws. One of the things that our firm does is really try and pay attention to the local laws as well as the FCPA to make sure that the companies are being consistent. And then when issues arise, the board needs to make sure that the issues that have arisen are investigated, that they're addressed, remediation measures are taken, that decisions are made whether or not the violations, whether or not they are violations, whether or not they should be reported, and the board needs to know and be active in overseeing how those issues are addressed.
Wendy, that is just an excellent list for anybody that's going to be going into any kind of foreign or emerging companies, and exactly what we're trying to cover here with the Board Governance Series. So I want to thank you for joining us, and obviously we just covered the tip of the iceberg, but it's a good refresher for everybody that's sitting on a board out there on what has to happen, and I want to thank you for joining us.
Thank you.
Wendy Wysong can be reached at wendy.wysong@cliffordchance.com. The Board Governance Series is a presentation of corporate board member in NYSE Euronext Company.